Hi, I'm firearms attorney Gilbert Ambler, and today we're back to talk about solvent trap kits one more time. And I think the reason we're talking about solvent trap kits again is because the ATF is running out of other things to focus on. They've currently been enjoined from going after pistol braces. They've been enjoined from going after forced reset triggers. What haven't they been enjoined on? Solvent trap kits. So now they've sent out a letter to FFLs informing FFLs, gun stores, that they believe most solvent trap kits are actually illegal suppressors. We are going to talk about what to do if you have previously purchased one of these kits today. We're also going to talk about a case. We previously discussed this case and we'll link to that video down below, where the ATF got a conviction for an undrilled solvent trap kit because that case has now been appealed. And the appeal shows sort of a blueprint on how the ATF got the conviction in the first place, and I think raises some valid issues that might overturn that conviction. But before we dive into this subject, if you have not yet hit that subscribe button, what are you waiting for? Go ahead, hit the subscribe button, like this video, comment with your thoughts, share with your friends. That way you and your friends can keep getting this important Second Amendment related content. Let's start with solvent trap kits. Because right now, with the ATF focusing on solvent trap kits again, there are many folks out there that bought one of these kits, and we're going to divide them into two categories. First category, you bought the kit, you haven't touched it, it is still in the format that you purchased it originally. Now, you should still be nervous about having it because, as we already know, ATF has already convicted at least one person for possession of an undrilled kit, and that person was sentenced to 3 years behind bars. So I would be worried about it. I don't think that, in my opinion, it meets the definition of a suppressor, but if the ATF can convince a jury, now we start to worry. And if you're worried, my advice to you is, if you have not yet received individualized communication from the ATF about that, a letter or a phone call or a visit, that you destroy it now. I know you put hard work into earning the money that you paid for that, and so financially it doesn't make sense to cut up something that you spent your hard-earned dollars on. But legally it makes sense, because if you wait to get individualized communication and then want to cut it up, at that point you will arguably be committing the crime of tampering with evidence through destruction. If you destroy it before you get contacted, then you're not committing any crime. So I would destroy it, I would get rid of the pieces, and I would take a picture of it in its cut up format so you can prove you don't have it anymore, you cut it up and got rid of it, okay? If, however, you bought one of these kits, you filled out a Form 1, you applied to the ATF, you got approval, and you then, after receiving approval, build it into a functional suppressor. Don't panic, but I do think you should talk to counsel. And the reason you should talk to counsel is because in the ATF's viewpoint, that item you bought already was a functional suppressor, and if it already was a functional suppressor, it should have been Form 4 to you, transferred, instead of Form 1 built, because you can't build something that already is. Now let's talk about that case, and this is the case of Hatchet Speed. I love his name, Hatchet Speed. He sounds like an action hero. But Mr. Speed, after getting the attention of the feds through his presence around the Capitol building on January 6th, got investigated for, indicted, and convicted for possession of unregistered suppressors for possessing 3 solvent trap kits. Now, the solvent trap kits for which he was convicted were still in the box that they came from the purchaser, and they had not been drilled out. So how did the ATF get a conviction on these? Well, he just filed the appellant, which is Mr. Speed, just filed his opening brief with the Fourth Circuit Court of Appeals. I have not read the transcripts from trial, but that brief starts to lay out what the government did. First thing you need to know is it was actually his second trial that he got convicted in, because the first trial ended in a mistrial. Now, between the first and second trials, the ATF went and they administratively seized the website through which Mr. Speed had bought these solvent trap kits. And by doing that, they were allowed at the second trial to argue that these solvent trap kits were no longer available online, that the seller has also been shut down. And of course, to the jury, that makes it sound more illegal. Mr. Speed, on the flip side, wanted to argue to the jury, and the judge did not let him argue to the jury, that he was aware that lots of neighborhood gun stores sold similar kits. And of course, he wanted to argue that because he said, this goes to whether I knew I was doing something illegal. This goes to my mens rea, my intent. I didn't intentionally possess anything that was a suppressor. Judge didn't let him make that argument. However, there were more egregious points that the judge also kept out and kept away from the jury. because the FBI had an undercover making friends with Mr. Speed. The undercover kept asking about solvent trap kits. And Mr. Speed, when he was being recorded by this undercover, without knowing that he was being recorded, so he wasn't just saying helpful things to try to help his case, this was truly what he believed, told the undercover, yes, I have some of these kits. They could potentially be built into suppressors, but you would have to get a Form 1 and get approval before you can drill it out. And I don't even own any of the drills, nor do I even know somebody who would be able to do this. The jury wasn't allowed to hear that video. The jury wasn't allowed to hear that video because the ATF, the prosecutors, filed a motion in limine to keep them from hearing the jury, and they argued that it would unfairly prejudice the jury against the federal government. Well, of course, because Mr. Speed was not trying to do anything criminal, and they didn't want the jury to hear that, and they argued that it was a mistake of law defense. Unfortunately, however, the test through this conviction for when you possess a suppressor has really been modified, because it used to be that you possessed a suppressor if you had a combination of parts through which a suppressor could be assembled. And this makes sense because you can't just take your suppressor apart when the ATF comes around and say, it's just pieces, and then as soon as the ATF leaves, screw it all back together and go back to the range. No, of course, you would be in possession of a suppressor if you had all the parts necessary to build one. But Mr. Speed had these parts, but they couldn't just screw together to become a suppressor. No, they had to be modified to become a suppressor. And they still got a conviction for this. And it's significant because nearly any device with enough modification could muffle the sound of a firearm, and therefore you could be convicted. So if the ATF is able to convince a jury that what you have in your possession can be modified to become a suppressor, then they might still be able to convict you. And that is a scary legal standard, folks, and one that I think the Fourth Circuit Court of Appeals should overturn. Finally, it was notable that the ATF was able to show the jury 3 examples of suppressors that Mr. Speed actually owned that were functional suppressors that he had properly registered. They showed them to the jury because they looked similar to the solvent trap kits, but Mr. Speed was not able to show the jury his paperwork showing that he had properly registered those 3 suppressors. And that paperwork's important because it shows he understood the law and wanted to comply with the law. Finally, I think that it is notable, I think it's interesting that when we're talking about this case, that Mr. Speed was generally probably viewed as an unlikable character. He had some personal beliefs that made him unpopular. I think that's the other reason the ATF singled him out. We talked about that in the prior video we filmed. And the defense attorneys, they don't really focus on that, as you might imagine. They do make a very interesting Second Amendment Bruin challenge argument to the NFA, and I doubt that the Fourth Circuit will take up that argument, but there are some of these other issues. The fact that they weren't allowed to present all of this evidence about his mens rea, about his intent not to do something illegal, which I think is relevant in this case. So we'll see what the Court of Appeals says. If you enjoyed this video, go ahead, hit that subscribe button. Until next time.